Hi everybody, welcome to the first video for Unit 4 for Legal Studies 3-4. In today's video, we're going to be covering the roles of the houses, the division of power, and Section 109 of the Constitution. So to start off with, this is a bit of an overview of the Constitution, which the Unit 4 content kind of revolves around. So the Constitution outlines the rules, functions, and limit of the Australian government, Australian Parliament, and the Australian court systems, and outlines the powers and duties of government. So it outlines what government can and can't do. The formal title is the Commonwealth of Australia Constitution Act, which was formed in 1901 at the time of Federation. And that's reflected in some of the content that we learned. So it's important to know some of the history of the Constitution and its creation. Also important to note, and we will cover this a lot more, but it creates the High Court of Australia, and it also outlines the different houses of Parliament, which is a really good segue into the first dot point for this area study. So the structure of our Commonwealth Parliament. So our Parliament is comprised of two houses of Parliament and the Crown. So we have the Crown and the Queen, who is represented by the Governor-General of Australia. We have the Senate, which is the upper house of Parliament, and we have the House of Reps, which is the lower house of Parliament. So to start off with, we're going to go through the House of Reps, which is the lower house of the Commonwealth Parliament. So the House of Reps is commonly known as the People's House because people elect a representative who sits in Parliament to represent their electorate. So as we can see, there are 150 members in the House of Reps, and each comes from the 150 electorates in Australia. It's also known as the People's House because the party with the majority of seats in the House of Reps forms government. So if the majority of seats are held by the Labor Party, then the Labor Party will become government and the leader of that party will become the Prime Minister. The main role of the House of Reps is to create laws which represent the views of the people because they are representative of the electorates and the people within those electorates. If legislation is introduced by the upper house, then they can also act as a house of review. But because the House of Reps comprises of government, a lot of the bills are introduced by the lower house. So the House of Reps doesn't so often act as a house of review. It more is responsible for actually introducing laws into Parliament. And finally, important to know is that the House of Reps also controls the government expenditure. And this is because the House of Reps is the only house that's able to present bills relating to the budget and money bills. And that's entirely just to ensure that the budget represents the views of the people. Next, we have the upper house, which is the Senate. So the Senate comprises 76 senators, 12 from each state and 2 from each territory. And so the Senate is commonly known as the state's house because it is representative of each state regardless of their population. Each has an equal amount of seats, 12, and to a lesser extent, it does also represent the territories. So the Senate, as we said before, because most of the legislation and bills are proposed by government in the lower house, the Senate has a primary duty of acting as a house of review. So when bills are introduced, they must first be passed by the lower house, then they come and they are voted on by the Senate. The Senate then has to consider all the issues and implications of that bill and make sure that it represents both the people and the state's views as well. If the Senate believes that there's something wrong with the bill and it's not a desirable law for Australia, then they can refuse to vote on that bill and it will be sent back down to the lower house for amendments, or it may be thrown out altogether. Another thing that we will go through later on in this course is the committees in the Senate. And so they, in order to enhance the role of the Senate as acting as a house of review, committees are bodies which can investigate proposed laws and make sure that they are in the Senate's best interest to pass them. And they can also investigate whether certain laws should be proposed by the Senate as well. And as we said before, the Senate can also, in some instances, pass laws and introduce them into Parliament, so long as they don't relate to the money and budget. Next, we have the Crown. So the Crown is represented by the Governor-General at Commonwealth level, and they are appointed by the Queen on advice from the Prime Minister of Australia. The Crown's main duty is to ensure that Australia's democratic system operates effectively. And the main way that they do that is by providing royal assent. So once a bill has been passed in both houses, it must be signed by the Crown, the Governor-General, on behalf of the Queen, in order for it to form good law in Australia. If the Governor-General did not believe that a law was in the Australia's best interests, they could effectively withhold that assent and refuse to make that into law, but that has happened very, very rarely. The Crown also appoints the executive, so they appoint the Prime Minister and the ministers who sit in government. The Crown also has a number of ceremonial duties to attend, large political events and represent the Queen in that respect as well. So now we move on to the Victorian Parliament. So the Victorian Parliament is actually structured in a very similar way. And so the Victorian Parliament also has a Crown who is represented by the Governor instead of the Governor-General, because this is Victorian. We have the Legislative Council, which is our upper house, and the Legislative Assembly, which is our lower house. The Legislative Assembly, which is the lower house, has 88 members, one from each district across Victoria. And again, everybody from each electorate, from each district, elects one representative, and they make decisions on our behalf. So they have to create laws which are representative of the people and reflect the views and values from the people from that respective district that they represent. Like the lower house of the Commonwealth Parliament, the Legislative Assembly also forms the Victorian government. So if the Labor Party has a majority in the lower house in Victoria, then the Labor Party will form the Victorian government, and the leader of the party will form the Premier of Victoria. And to a lesser extent, like the Commonwealth Parliament, they can also act as a house of review. The Legislative Council is our upper house, and so that is comprised of 40 members, 5 from each of Victoria's 8 regions. So one of those regions is metropolitan Melbourne. There's like northwestern Victoria, northeastern Victoria. So it's quite large chunks of the state. And so that again is just to ensure that it's not only the most populous regions of Victoria, like inner city, metropolitan Melbourne, that are dictating policies, that also regional areas are being considered. So the Legislative Council, similar to the Senate, acts as a house of review because most of the legislation is passed by the Victorian government in the lower house. Alike at Commonwealth level, there's also committees who can scrutinise the legislation that's proposed by the government and decide whether the Legislative Council should pass it through or not. And to a lesser extent, the Legislative Council also has a role to introduce legislation into Parliament. And the Crown has the exact same roles as the Crown for Commonwealth Parliament, except the only real difference is that it's the Governor of Victoria representing the Queen instead of the Governor-General at Commonwealth level. Now moving on to the next dot point. So the division of powers is the jurisdiction of state and Commonwealth parliaments to make laws. So the first type of power that you need to know is residual powers. So residual powers are only areas that states can make laws on. And so residual powers are not listed in the Constitution. Anything that is not specifically listed in the Constitution is a power of the state. And the reason for this is because, going back to the history of the Constitution was formed at the time of Federation. Prior to the Constitution, each state was its own country effectively. So rather than writing all the things that the state could do, they just wrote down the things that the state could no longer do now that it was a part of the Australian Federation. So remember that anything that's not specifically enshrined in the Constitution is a residual power. An example of that is transport, criminal law, we have our own police system, we have our own court system, and education, we have our own VCE system. Exclusive powers are instead powers that are only to be exercised by the Commonwealth Federal Parliament. So states have no jurisdiction to make laws in this area. All exclusive powers are outlined in Section 51 and Section 52 of the Constitution, and they include things like defence, currency, and immigration. So things where it's required for there to be one common law in Australia rather than each state having separate laws. Concurrent powers are areas in which both states and the federal Commonwealth can make laws on. And so they share lawmaking powers over those areas. Examples are tax, we have state and federal tax, trade between states, and trade internationally is concern of the Commonwealth, marriage and divorce, and the post. Another thing to remember is sometimes the phrase specific powers comes up. Specific powers are just anything that's listed in the Constitution. So anything that is not a residual power. So exclusive and concurrent powers are your examples of specific powers. And finally, the last dot point for this video is Section 109. It's really good to know the wording of Section 109 and use that in your writing. So Section 109 states that when a law of the state is inconsistent with the law of the Commonwealth, the latter, the Commonwealth, shall prevail, and the former, the state, shall, to the extent of the inconsistency, be rendered invalid. So in plain language, what that means is that if there is an inconsistency between state and federal law, the federal law will be the one that remains good law. And the state law will become invalid and no longer have any effect at all. But only so far as the extent of the inconsistency. If possible, they will try to save as much of Victorian law as possible. So rather than getting rid of the whole section, which is inconsistent with the federal law, they may just get rid of the word that is inconsistent. And the purpose of Section 109 is to resolve conflict and create consistency between the laws in the Commonwealth. The Section 109 actually acts as a restriction on state parliaments because remember talking back to concurrent powers. Concurrent powers are areas that both states and the federal parliament can make laws on. However, as per Section 109, as soon as the Commonwealth makes a law in an area of concurrent power, the state has no power to change it. They have to either pass the same law, or if they were to pass an inconsistent law, it would be rendered invalid under Section 109. So Section 109 restricts the state lawmaking powers significantly, and we'll explore that in the McBain case in a second. In order for a state law to be rendered invalid under Section 109, an individual who has been affected by that issue has to challenge the state law in the High Court. Another thing to remember is that if the Commonwealth law is later abolished, the state law that was previously made invalid will come back into force and become good law once again. So now this is the case of McBain, which gives you a good understanding of Section 109 and its application. So in this case, Section 8 of the Victorian Infertility Treatment Act said that in order for a woman to receive IVF, they had to have been in a genuine relationship or living with a man. And it specifically specified a man. So it specified, heterosexual relationship. Conversely, the Commonwealth Sex Discrimination Act said that it was unlawful to refuse to provide a service to another person on the grounds of a person's marital status. So in this case, Dr. McBain was an IVF specialist, and he wanted to provide IVF to a patient, Lisa Meldrum, who was not married and was not living in a de facto relationship with a man. And so she wanted to receive IVF treatment, but by providing her with IVF, he was breaking the Victorian law. However, if he refused to provide her with the service, he would be breaking the Commonwealth law. because he was refusing to give her the service on the basis of her marital status. And so this is where an inconsistency arose. And it wasn't so blatantly obvious. It was only once the actual application of the Infertility Treatment Act was carried out, and it's not specific and clear in the wording that these two things would be inconsistent. And so Dr. McBain was genuinely affected by this issue. He had standing, he would be breaking the law either way. And so he took a claim to the court, and the court said that Section 109 should be applied, and the Victorian law was therefore rendered invalid. And instead, the Victorian law was replaced with a new piece of legislation, which stated that a doctor can provide IVF if they're satisfied that the woman is unlikely to otherwise become pregnant. So there was no mention of marital status or relationship at all. So that's how Section 109 is applied. And that brings us to the end of that video. In the next video, we'll be covering the checks on Parliament. Thanks.